Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to another episode of Just Champions. And I'm really looking forward to today's episode because I am sitting down again with Ron Eisenberg, who I know is an extraordinary attorney, but as you know from last season, he's so much more. And in that time, you have a new title, Executive Deputy Attorney General and Chief of the Civil Division in the Pennsylvania Attorney General's Office. And prior to that, Ron, for 6 years before that, was serving as supervising attorney in the Pennsylvania Office of the Attorney General also, where, among other things, he oversaw the office's state and federal appellate work, their legislative activity, and civil litigation. Ron has argued cases before appellate and Supreme Courts, the Supreme Courts of Pennsylvania and the U.S. Supreme Court. He went to the University of Pennsylvania Law School. And like Ed McCann, who is also a guest and someone we've spoken to, he and Ron and I are all alumni of the Philadelphia DA's office. And none of us work in the same office anymore, but I think this is a testament when you are in a career and in a place where you have shared goals and intellectual collaboration and working towards something bigger than yourself, the bond continues. And I'm very, very lucky that I'm here with Ron today and very happy we're here because we're going to be talking about due process and the Fifth and Sixth Amendment, things you know a lot about. And I am here to learn a lot.
Nice to be here with you, Jennifer.
As I think you know, one of my favorite quotes is from a U.S. Supreme Court case about justice. Do the accused is do the accuser as well. This need to keep the balance true. And I think talking about that in practice and talking about why as prosecutors it's important for us and why as part of our practice we think it's important for us to keep fairness for defendants and people accused of crimes and how we keep that balance to make sure that victims' rights are protected as well and the victim's voice is heard as well. So the right against incrimination and the right to an attorney, can you talk a little bit about the genesis of those things?
Well, the genesis of it is the United States Constitution. For our purposes, that's the relevant starting point, the Fifth Amendment and the Sixth Amendment. The Fifth Amendment is about the right not to incriminate yourself. The Sixth Amendment provides the right to counsel. Those rights have been greatly expanded over the years and centuries, and especially since the 1960s, to the point where you have a lot of very well-developed laws, a lot of specific rules that didn't used to exist, and a lot of litigation, a lot of arguing in court about how we try cases and what kind of evidence can be used.
In fact, you talked about them being embodied in our very Constitution, basically created out of years of persecution and rules that didn't protect our citizens. And so can you talk about why this rule is important, even though it might make it harder to achieve justice in cases with very violent individuals who are accused of horrific crimes?
Well, you're right, Jennifer, that it's really a balance. We're trying to balance the search for truth and the accurate determination of guilt and innocence against the procedures that have been developed to protect criminal defendants. And there can be a lot of policy debate about exactly where that balance should come out. People are probably familiar with the idea of search and seizure and the suppression rule. If that's not the Fifth or the Sixth Amendment, that goes back to the Fourth Amendment. If police search you in a way that is against the law, then the evidence cannot be used against you, even if it's completely reliable and completely incriminating evidence. it gets suppressed. And very often in those cases, the defendant gets off. He cannot be convicted, even if there's pretty much unimpeachable evidence to show guilt.
Can you talk a little bit about, even with horrific individuals, why we are so ingrained and so against forcing confessions and trying to create circumstances where people feel compelled to give statements and where they don't have protection against giving evidence against themselves?
Well, I think one of the main concerns is that we want to make sure that the evidence is true. And if you could really compel somebody to speak, and this is, I think, the core of the Fifth Amendment, then they might say whatever they think you want to hear, even if it's not true. So, the foundation of the Fifth Amendment is you beat somebody up to get him to confess, quote unquote. He might be confessing to something he didn't actually do just so that you'll stop beating him up. Now, we've taken that basic idea, which is not just a matter of fairness, but of making sure we've got the right guy, and we've surrounded it. We've fenced it off with a whole variety of additional rules. And probably the most famous of those these days is Miranda. Pretty much everybody's heard of Miranda rights, even though they might not know the genesis of them, which I think that's something that you can talk about more. But we've really gone well beyond just the idea of not being able to beat somebody into confessing, starve them into confessing, in any other way sort of physically or emotionally threaten them into confessing, to the point where not only can't you do that, but you can't ask somebody incriminating questions without first having educated him a bit about his constitutional rights, about the fact that he doesn't have to talk. And, we actually go a little farther in this regard than a lot of other countries do. So there could be legitimate debates policy-wise about where these lines should be drawn. I'm a big fan of the British detective show. I can't believe how many there are. I'm on Amazon Prime and other services, and there's zillions of them. And when they arrest somebody, they don't say the same things to them that we say in the United States. They have different warnings, which are a little less forgiving than ours are. That's just where they come down there.
Can you talk about those Miranda warnings? Now, I mean, what is it in essence? What are we telling people? You're arrested for a crime, and what's the first thing we're telling them?
We're telling them, you're arrested for a crime, and we're the police, and we have the right to arrest you, but you don't have to talk to us if you don't want to. We'd like to ask you about this crime and the evidence that we have, but you don't have to answer. And you should know you don't have to answer, and you should know you have a right to an attorney, and you can invoke your right to an attorney. And if you do, we have to stop talking to you until your attorney says otherwise. So, as I say, it's a very forgiving regime that doesn't quite beg the defendant not to talk, but certainly encourages him not to talk. And a lot of criminal defense lawyers, I'm sure, would say that they always advise their clients not to waive their Miranda rights. Don't tell the police anything.
Yeah, why is the right to an attorney also so ingrained? Because you're right. You go around the world. We do a lot of trainings around the world, and that's not a right that's everywhere. And here in the United States, you have a right to an attorney provided at no cost to you when you're arrested for a crime. Can you talk a little bit about that?
That's historically a relatively new development. I mean, it's old for those of us alive today. It started back in the early 1960s with Gideon versus Wainwright, where the court said that when the Constitution says you have a right to an attorney in a criminal case, it means that if you can't afford to hire an attorney, we're going to give you one for free. And so we've had a whole development of public defender systems, et cetera, since that time to make sure that that right is provided. And there continues to be debate. Are there enough public defenders? Are there enough defense counsels paid by the courts? Do the courts pay them enough money? Have they hired enough of them? Did they give them enough time? We have all those debates all the time in the system. But the basic idea is, despite whatever the police might advise you in your Miranda rights, the assumption of the system is that people who are arrested, especially if they're not lawyers, not criminal lawyers, don't fully appreciate all the laws that apply to them. And in order to properly exercise their rights, in order to make intelligent decisions about how to proceed through the system from the very beginning, from the arrest onward, they need to be able to consult with a lawyer.
I feel like as a lawyer, I grew up in the Philadelphia District Attorney's Office in the late 90s under Lynn Abraham with people like you and Ed McCann, and just a real true appreciation that you yearned for defense attorneys, for public defenders who were at the top of their game, who were prepared, who were doing their job, not only to maintain faith in the system, but to help the process of the case. I mean, it's a very important piece of a criminal prosecution of this adversarial system, even though as prosecutors, when we're in the courtroom, we believe that the defendant, beyond a reasonable doubt, sometimes beyond all doubt, has committed the crime, and that we have evidence that proves it beyond a reasonable doubt admissible. And yet still wanting to have a capable defense attorney was something that we really wanted, and I was grateful that that's part of our system.
Yeah, and I think it might sound a little paradoxical to some people. I'm sure there's some people that wouldn't believe it, but I think in the long run, the prosecutor's job is made easier by having competent defense counsel on the other side. Among other things, if you don't have a good defense lawyer, you get to challenge your conviction on that ground. The Supreme Court has developed the law under the Sixth Amendment in that respect also. And they have said that the right to counsel is the right to the effective assistance of counsel. And so the courts are filled with claims by defendants who have been convicted saying that their lawyers provided ineffective assistance of counsel. It's one of the main issues that you see in every criminal appeal. But even before you get to the appeal stage, I think that the trial is more likely to proceed smoothly and fully if the lawyers on both sides are competent. That goes not just for the defense lawyer, but for the prosecutor also. You want prosecutors who are well-trained, who know the law also, and who are not going to be fooled into doing things that might help the defendant but aren't required by the law.
And I know as an appellate attorney, and I've only known you ever in that position. So we're doing the trials, and yet we were lucky enough in that office to be able to consult with the appeals unit. Sometimes you could consult with them when you're on trial, trying to understand issues better, make sure you're putting your case in a way that will make a solid record and will not be reversible. And sometimes you in the appeals unit are taking the decisions that are being handed down, and you're bringing them to us proactively as trial attorneys to make sure we're aware. Can you talk a little bit about that role of the appellate attorney and your experience with that?
Sure. As we've discussed, the law changes. I mean, the Constitution doesn't change except when it's officially amended, which doesn't happen very often. But interpretations of the law develop over time. And that happens not just in the United States Supreme Court, but in lower federal courts and in the state courts. And so the law is always changing, and trial prosecutors may not always be aware of the latest appellate decisions, but those decisions are going to apply to their cases when those cases get appealed. So better to be proactive and put those developments of the law into effect at the trial level so that we're not facing those claims years down the line at the appellate stage. People, I think, don't really realize it, but it feels like criminal cases never die in a way, because appeals can go on and on. I won't say forever. I would say the life of a criminal case is pretty much equivalent to the length of the sentence the defendant receives. So if the defendant gets a 10-year sentence, he's going to find ways to appeal. In most states, he's going to be able to find ways to appeal for most of those 10 years. If he's got a life sentence, it's going to be appeals pretty much for life. You don't just get one appeal in practice. So given all that stuff on the back end, the trial, which the Supreme Court has famously referred to as the main event, is really timeline-wise, only a small portion of the life of a criminal prosecution.
And, it's so funny that you talked about these cases evolving, because one of the cases, talking about Miranda, and I'll get into the facts of that case a little bit in a moment, but that is enshrined from the 60s, as you said, and I don't know if this is legally correct, but when you think of Gideon, it's sort of rolling its way as a part of the Miranda decision, this right to counsel. being part of the Miranda warnings that you have to give. But Miranda itself was interpreted even in the mid-2000s in two different cases, clarifying this 14-day rule. Again, this is another case involving sexual abuse. And I like to point these out because there have been so many cases involving child abuse, sexual abuse, domestic violence, stalking that start out as local cases. They may even start out as protection from abuse orders, and they make their way to the highest court of the land, and they create a landscape for constitutional law. But, Miranda twice interpreted about the 14-day rule and then clarifying what it means to invoke and remain silent. And I thought that was really interesting, too, that these cases are never really final.
Right. And the law is never really final. And there's always more argument to be had. In fact, there was an argument in the U.S. Supreme Court several years ago, maybe 10, 15 years ago, about whether Miranda should be completely overruled. Because, nothing... If you go to the Constitution, Fifth Amendment, Sixth Amendment, any part of the Constitution, you're not going to say anywhere where it says the defendant has to be given warnings before the police can question him. The Supreme Court came up with that idea on their own as a way to apply the Fifth Amendment basic right to self-incrimination. And there were arguments for many years after that the Supreme Court had gone too far and that they shouldn't have required those Miranda warnings. And that, in fact, the court should overrule Miranda. And in a case called Dickerson versus the United States, the Supreme Court reaffirmed the original Miranda warning some 40 or 50 years later and decided, no, we're going to stick with what we've got. It's become comfortable. A lot of people can recite those warnings just from watching TV themselves and their own detective shows. But these, could happen again. These things are always in play, let's say.
And this is a little bit of a turn in a slightly different direction, but in appeals, I think the other thing I'm struck about appeals and in your work is not only the evolution of the law, but that the fact that in an appeal, you don't have a witness. You don't have witness testimony. You're, I don't want to say stuck with the record, but you have the record as it's given to you. And sometimes, honestly, in rereading Miranda just to get ready for this conversation, I realized they don't even go into the facts, the underlying facts of that case, which involved a serial rapist who kidnapped and raped an 18-year-old girl who was coming home from the bus from her job at night, took her to a remote area, violently raped her, and was actually suspected of several rapes throughout the area where she lived. And, having to find those facts meant having to go to the lower court opinion. So how do you bring the victim's voice into the appeal?
I think that's a really important point, Jennifer, because I think there's an illusion among lawyers that facts shouldn't matter on appeal. Facts shouldn't matter to the development of the law. If we're debating about whether there should be Miranda warnings or what exactly they should say, or whether you can question the defendant again 2 weeks after you last gave Miranda warnings without repeating the warnings, you could look at all those as pure questions of law, but they're really policy debates, as I said before, exactly where we draw the line, how we balance the rights of the defendant against the rights of the victim, and not just the victim, but against the public as a whole to a functioning criminal justice system. Those are all policy questions that can and are debated. And I think that the facts are not properly separated from those decisions because those decisions are not dictated, pre-dictated by the law. The U.S. Constitution didn't say from 1780, whatever, that you must give those Miranda warnings. Because there are policy decisions to be made, you need to understand what the costs are on both sides of the equation. And those costs on the prosecution side, on the public side, on the side of the people are often conveyed by paying attention to the facts of the crime. And you need to know what you're giving up when you put limitations on the ability of the public to present evidence in court. I think that's where the importance of facts comes in at the appellate stage.
It was really interesting. In the last season, we had Abigail Breslin on, who had played the victim, Trish Weir, in the Miranda case, Miranda v. Arizona, and really talking about her experience, bringing the victim's experience to life. But we really dove into that case. And I know because we're talking about due process here, there was another case also involving a brutal sexual assault. And this was the district attorney's office for the 3rd Judicial Circuit District, a little bit of a mouthful there, v. Osborne. And this was a case where the defense sought to, this is our case of the day, if you will, where the defense sought to have the court basically initiate a federal due process right in testing. And again, this is a case, you're having these very technical arguments. It was a case that involved an action brought under 1983 action. And it was a case, though, that was so technical, but it sprung up from such common sexual violence crime. And when I say such common, in that a sexual violence case, a horrific rape and attempted murder of a sexually exploited woman, whom the defendant and co-defendant picked up on their way driving out to a remote area, agreed to exchange money for sex. When they got out to where they were, and again, these facts are lost because this case, has a holding, obviously, about DNA testing and does a defendant have a federal right, or do the state post-conviction rights attached to that? But before we get into technical legal questions, just this story about a woman who is marginalized, very vulnerable, goes out to a remote area, already dangerous, in negotiating for the cash before the exchange. The defendants end up being so, I guess, enraged by the audacity that she would ask for this. They pull a gun out. They orally and vaginally rape her. Then they order her out of the car. They're in a remote part of Alaska. This is where this case takes place. They order her to lie face down. Of course, she's terrified and she refuses to do it. They persist to strangle her, the two of them, shoot her in the head, kick snow over her, and leave her for dead. And miraculously, and the trial court called it a miracle that she survived this. Miraculously, she was able to get up from the scene, flag a car down, get medical attention, report to police. The police did exactly what we would have wanted them to do. They went back to the scene. They recovered a condom in the scene. They recovered other evidence at the scene that squarely brought the defendants, and this was outside of any of the DNA in the condom, but squarely tied the defendants to the area. Actually was writing down all the different pieces of evidence that they found. And I just want to pause for a second. I know I get very animated because it's so violent. And I guess two pieces. One, I think this case is so important because it reminds people of how dangerous it is, individuals involved in the sex trade, and how important it is to provide protection, equal protection to those individuals when they're victims of crime. And it also points out this was a horrific case. And like I said, the evidence was overwhelming. There was a spent shell casing that was found at the crime scene that ultimately matched a gun that was found on one of the defendants. There was an axe handle. Oh, I left that out. Before they shot her, they beat her with an axe handle. The victim's clothes were there. And then days later, when the one defendant is stopped, in the car is found the gun that matches the shell casing. He names the other co-defendant, who's Osborne in this case, and there's other implements found in that individual's apartment. So it's a horrific case, and yet we still gave these individuals a forum, went up to the highest court in the land to ensure that the evidence and the process was fair.
Well, I think you're right, and I think it shows that, as I said, criminal cases tend to never die. DNA might seem like an easy one for people. Like, well, of course, why wouldn't you give the defendant the right to always check the DNA? And the Supreme Court didn't exactly say you can't. What they said is some things we can leave to the states to figure out. And in this case, the state did give the defendant what the court found to be an adequate right to check for DNA testing. But I think that what people miss in sometimes seeing the criminal justice system in black and white applies to DNA also, which is that DNA in many cases, I would say these days, maybe even in most cases, is not an automatic yes or no on guilt. Because there's a lot of DNA that can be recovered these days from a lot of different places around a crime scene. So finding the absence of the defendant's DNA doesn't necessarily tell you that the defendant was innocent. Finding the presence of the defendant's DNA is usually going to be much more probative, much more reliable evidence of the defendant's involvement. But even that is not always necessarily going to be proof beyond a reasonable doubt of guilt. DNA can be very tricky, especially because we're often talking about touch DNA. You touch a surface, and there are many surfaces from which the police can recover your DNA even years later. And so, maybe you were there on the day of the crime, maybe you weren't. Maybe you were really participating in the crime, but you didn't touch the right kind of surface from which your DNA can be recovered after the fact. So even in the DNA area, there are tricky policy balancing decisions to be made about the rights of the defendant versus the rights of the public.
And, I also think it was interesting because you talked earlier in this conversation about ineffective assistance of counsel claims. And this was, one of those areas where the type of DNA testing done was not of the same sophisticated type, let's just say, that was available at the time. And in fact, that wasn't a case of ineffective assistance. That was a strategy case because this defendant's counsel made a decision that the evidence was so overwhelming against her client that the better strategy was to argue doubt based on the, we'll just call it the lower level, the more initial DNA testing that they did versus doing the more comprehensive testing, which would have eliminated all doubt. And so that I thought was another really interesting piece of that case.
I think it's a good point. Lawyers, defense lawyers, and prosecutors are always making choices. You can't do everything. You decide to defend your client on the ground that he wasn't there, well, then you are automatically giving up arguments that he was there, but he didn't really participate very much in it, or that it was self-defense or whatever. There's no way around those choices in the criminal justice system. And if the choice made by the lawyer and the client, hopefully consulting together, doesn't work out and the defendant gets convicted, then it's only natural that the defendant is going to say, my lawyer made the wrong choice. He should have chosen a different strategy because the one he picked didn't work.
Yeah, I think these are just really important reminders for individuals. And just, again, just going back to a couple of things in the case. I mean, we don't speculate, but you talked about DNA not being dispositive. I mean, as a longtime sex crimes prosecutor and someone working on this my whole career, what I do know is even in these stranger cases, had the rape trial come forward and perhaps had this level of violence not been exacted at the victim during the course of the rape, a consent defense is something we would have definitely prepared for because we see that thrown at our victims all the time. And so even in cases with DNA and, some of the reasons why there were all these untested rape kits for so long, some of those victims were individuals, sexually exploited individuals who the police or prosecutors may not have thought were credible cases, which is a shame and which let a lot of serial rapists free.
You touch on an important point, which is the law is a developing process, and some of the ways in which the development, I would say, have lagged have arisen, particularly in sexual assault and domestic violence cases, because historically there were ways in which they weren't taken as seriously. Or as you just said, where the claim was, oh, she's a prostitute, so don't believe anything she says. That's an old story in the law, and I think it's one that we're still trying to work through. Still trying to fix.
Oh, absolutely. And again, you're one of the people out there who's fixing it on so many levels. I mean, and I think of it back in the Philadelphia DA's office, helping us at the level within the Commonwealth. And then, further up through the different appellate courts and the Supreme Court, and now at the Attorney General's office, not only in the appellate and the civil litigation, but just in managing and working with an office that's also responsible for implementing and upholding laws and really giving guidance to the prosecutors across the state. And those cases go up to the Supreme Court, so they have implications across the country. So thank you so much for that. And before I let you go, I have some rapid fire questions that I like to ask people. The first question is, what's the hardest lesson you've learned in the courtroom?
It's certainly an early lesson, or hopefully will be an early lesson for lawyers. You go to law school and you spend all these times reading case books and learning for the bar and what's the rule of this versus the rule of that and all of its subparts. And I think it took me a while to recognize that in my opinion, most criminal cases are decided on the facts, not the law. The law's a background. Yes, it sets the stage for how we're going to present evidence and how the appeals are going to process. But the result of the case, certainly at the trial level, but even on appeal, often turns on the specific facts of the case. So pay attention to those, lawyers, and figure out how to convey them, because it's not just about, dusty old law books off the shelf.
Very true. Okay, next question. What would you tell young Ron Eisenberg about this work? Young you.
Don't expect to get rich.
That's an understatement.
I guess I knew that when I was young too, but you don't think about that stuff as much at that time. But think hard about that. If you want to be a career prosecutor, you're not going to be in the same place at the end where your classmates who went on to big law firms are going to be.
Intellectually rich, though, and I would say spiritually rich.
I think
the good work, right?
I think much richer. I never fully explored the other side of private practice, but it feels like it's certainly been interesting and exciting.
All right, and last one. What keeps you coming back to this work, even when it's tough, a tough decision or a tough case?
It doesn't feel done. There's lots of big legal battles that we have fought over the years, and yet new ones keep coming up that seem really important and that I think are going to affect the system as much as anything I've done earlier in my career. So, at some point I have to hang it up. My wife tells me that regularly. I'm not quite there yet.
Yeah, don't hang them up yet. You're not done yet. Ron, I know you're very, very busy.
Thank you so much
thank
for
you
having me,
so
Jen.
much for sitting down with us. And thank you so much for being the champion that you are. This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.